Welcome back to the Workforce Dilemma, and today we're going to talk to you about the Crown Act. The Crown Act now operates as a mainstream civil rights protection, with more than half of the U.S. states prohibiting hair-based discrimination, and additional states will be joining in 2026. For HR, this means dressing and grooming policies must be analyzed through the lens as race discrimination. The Crown Act, creating a respectful and open world for natural hair, typically amends existing anti-discrimination laws so that race expressly includes natural hair textures and protective styles such as locks, braids, twists, and afros. As a result, adverse actions tied to those hairstyles are treated as race-based discrimination in employment, housing, education, and other covered areas. As of the end of November 2025, 25 states have enacted Crown-type protections, with Pennsylvania the most recent addition. A federal Crown Act has been repeatedly introduced but not yet enacted. The current H.R. 1638 Crown Act of 2025 would add hair-based discrimination to key federal civil rights statutes if passed. Until there is a federal law, compliance remains a jurisdiction-by-jurisdiction exercise, particularly for multi-state employers. In Crown Act states, blanket bans on locks, braids, afros, or requirements to straighten hair are high risk and generally unlawful unless narrowly tied to legitimate safety or hygiene needs and consistently applied. The real-world impact includes your hiring, your promotions, your termination decisions cannot be based on how people wear their hair. Discipline, when made through those contacts, can also expose employers to discrimination claims and potential legal liability. And don't forget, when it comes to company culture, the Crown Act compliance requires you to create an inclusive environment where all employees feel respected and valued for their authentic selves. So HR should really review their dress and grooming policies, audit any hair-related discipline or hiring decisions, update anti-bias training, and ensure that religious and cultural hair practices are considered in the accommodation process. For those of us, or those of you, who have multi-state employer challenges, it's a patchwork of compliance. Different states have different requirements, different complexities. You need to standardize your policies. Consider adopting the most protective standard company-wide to ensure consistent treatment and reduce administrative bias or burden. And finally, make sure you have documentation. Maintain your processes through records showing that you have made decisions based on legitimate and non-discriminatory factors. When it comes to best practices, be proactive. Start looking at policies now. Don't wait for your state or your local government to enact something. Do it now. Start doing equip your upfront line managers with tools and recognize unconscious bias to make better employment decisions. And foster an environment where employees feel comfortable expressing their cultural identity through their appearance. The number of Crown Act states has increased quickly over the last 5 years, and more than 50 cities and counties have adopted their own hair discrimination ordinances that may go beyond state law. Recent actions such as Pennsylvania becoming the 28th state with hair discrimination law in 2025 suggest continued momentum. So HR should track both state and local developments in their footprints. And our advice is make sure you work with your compliance teams and your legal teams to make sure that you are staying informed, acting now, leading with inclusion. Leave your comments below on what you are doing or what your employer is doing. We look forward to hearing from you.